Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
American national Charles Marvin Romig died intestate, or without leaving a will, on November 20, 2011. At the time of his death, Romig was living in Oriental Mindoro, Philippines. On March 13, 2012, his sole heir and the representative of his estate, Maricel Narciso Romig, executed an affidavit of self-adjudication that adjudicated to herself the properties left by Charles, including a dollar deposit account with the Hong Kong and Shanghai Banking Corporation, or HSBC Limited. In May of the same year, the estate filed an estate tax return and paid the estate tax due amounting to 26,151 pesos. The estate, through Maricel, also submitted a letter to the Bureau of Internal Revenue requesting a confirmatory ruling as to whether the HSBC USD savings account was exempt from estate tax and all other taxes in accordance with Section 6 of Republic Act No. 6426, or the Foreign Currency Deposit Act of the Philippines. In June 2015, the estate filed an amended tax return and paid an additional estate tax on the foreign deposit amounting to more than 4.5 million pesos. However, on June 28, 2017, the estate filed before the BIR an administrative claim for refund of allegedly erroneous paid estate tax amounting to over 4.5 million pesos, including interest and penalties on the HSBC USD savings account. On the same day, the estate also filed before the Court of Tax Appeals a petition for review in view of the 2-year statute of limitations under Section 229 of the 1997 National Internal Revenue Code. The CTA en banc ultimately decided in the estate's favor and ordered the Commissioner of Internal Revenue to refund or issue a tax credit certificate in favor of the estate of Charles Romig. It found that the provisions of the 1997 NIRC, as amended, which is the general law on national internal revenue taxes, cannot impliedly repeal the Foreign Currency Deposit Act, a special law that governs the foreign currency deposit system in the Philippines. This prompted the Commissioner of Internal Revenue to elevate the matter to the Supreme Court. Now comes the question before the Supreme Court. Are foreign currency deposit accounts exempt from estate tax under the Foreign Currency Deposit Act of the Philippines? Hi, I'm Atty. Mike Navallo, Supreme Court Chief Communications Officer. It's the 6th of June 2025, and today we talk about whether foreign currency deposit accounts are exempt from estate tax under the Foreign Currency Deposit Act of the Philippines, within the context of the case of Commissioner of Internal Revenue versus estate of Mr. Charles Marvin Romig, represented by its sole heir, Maricel Narciso Romig, GR number 262092, penned by Associate Justice Ramon L. Hernando, decided on October 9, 2024. And joining us to talk about this case is Court of Tax Appeals Associate Justice Jean Marie A. Bacorro-Villena, member of the Department of Taxation Law of the Philippine Judicial Academy. Hi, Justice Jenny. Thanks again for joining us and welcome back to the Supreme Court Podcast.
Thank you, Attorney Mike, and hello again.
All right, thanks again, Justice Jenny, for allowing us to visit your office in the Court of Tax Appeals. Now, for the benefit of our non-lawyer listeners, Justice Jenny, what do we mean by estate? Just so we can start off the discussion with the background.
Okay, estate, when used in connection with probate proceedings, covers the totality of the assets and liabilities of a dead person or the decedent.
And we have an estate tax. What do we mean by estate tax, and who are supposed to be required to pay for it?
Okay, so the estate tax is the tax on the privilege of the decedent to transmit the property at the time of death. As such, it is in the nature of an excise tax, that is, tax on the enjoyment of the right or privilege and not a property tax. As to your question, who is required to pay the estate tax? Well, the executor or the administrator of the estate has the primary obligation to pay the tax, but the heir or the beneficiary has subsidiary liability for the payment of that portion of the estate which his or her share bears to the value of the total net estate, subject, of course, to the limitation that the said liability shall not exceed the value of his or her share in the inheritance. When there are, however, two or more executors or administrators, all of them will be severally liable for the payment of the tax.
Mhm. And when is it due? When do you pay estate tax? Is there a deadline for filing and payment?
Okay, so upon the death of the decedent, when the succession opens up and the privilege to transmit properties arises, the estate tax accrues. However, we must note that the accrual of the tax is distinct from the obligation to pay the same. As to the time of payment of the estate tax, well, as a general rule, the estate tax imposed under the NIRC shall be paid at the time the executor, administrator, or the heir files the return. It may be extended if the CIR finds that the estate or any of the heirs would have a difficult time to pay. In such case, the time for payment may be extended to a period not exceeding 5 years in case the estate is settled through the courts, or 2 years if settled extrajudicially.
And sometimes, Justice, there's an amnesty for this?
Yes, there are also amnesty provided. Now, as to your question, as to when the estate tax return should be filed, it
Mhm.
should be filed within 1 year from the decedent's death, and that also may be extended in meritorious cases to a period not exceeding 30 days. But please note that the reglementary periods that I have mentioned are under the amendments brought about by the tax reform for
Mhm.
acceleration and inclusion law, or what we call train law.
Mhm.
The estate of Romig case was decided prior to the enactment of the train law.
Mhm. Right. Thanks for that reminder, Justice Jenny. But how is estate tax different from inheritance tax?
Estate tax is imposed on the privilege of the decedent to transmit property at the time of death. On the
Mhm.
other hand, inheritance tax is a tax imposed on the privilege of the heirs to succeed or receive their individual share. Please note again that the inheritance tax was repealed. It's
Mhm.
already repealed under PD 69, or the 1973 amendments to the NIRC of
All right.
1939.
So it's good to put it out there because our listeners might be thinking, I'm paying estate tax and I'm also paying
Yeah, so
inheritance
double
tax. So
payment.
it's good to
So
know that there's no double payment.
yes.
All right. Now, in this case, Justice, why did the estate, represented by Maricel Rumig, initially pay only 26,151 pesos as estate tax?
The estate of Romig, in filing the first estate tax return, did not include the HSBC US dollar savings account, that is the foreign currency deposit account, in Romig's gross estate.
Mm. And so the case didn't say, Justice, if the Commissioner Internal Revenue replied to this letter because they wrote a letter, right, to the
Yes.
BIR claiming exemption. But we know from the facts that they eventually filed an amended estate tax return and they paid 4.56 million pesos. But they also asked for a refund
Yes,
subsequently.
yes.
What was the position of the Commissioner of Internal Revenue regarding the estate's request for refund of the estate tax paid on the dollar deposit account?
The CIR was of the position that, notwithstanding the existence of Section 6 of the Foreign Currency Deposit Act, or what we call FCDA, the estate of Romig was not entitled to a refund of the payment of estate tax for the transfer of the foreign currency deposits to Romig's heir, because the decedent, although an American citizen, was a resident of the Philippines. Being such, the CIR was insisting that all of Romig's properties, wherever situated, were subject to estate tax in accordance with Section 85 of our tax code. Further, the CIR argued that a foreign currency deposit of a resident decedent is not among the allowable deductions from the value of the gross estate of the resident alien under Section 86, Paragraph A of our tax code, nor is among the acquisitions and transmissions which are exempt from estate tax as provided under Section 87 of the same code. I must say, Attorney Mike, that this case appears to present a clash between Section 84 in relation to Section 85 of the NIRC, which
Mhm.
subjects all properties of Romig, being a resident alien, wherever situated, to estate tax, and Section 6 of the FCDA, which broadly exempts foreign currency deposits from the imposition of any and all taxes.
So there really is a clash
Yes.
justice in this case. And it's interesting because when the case went to the Court of Tax Appeal Second Division, it actually ruled in favor of the estate. So what was the basis for saying that the estate was actually entitled to a refund because there was erroneous payment of estate tax?
The CTA Second Division, for which I was part of that, Attorney Mike, the CTA Second Division's basis for ruling in favor of the estate of Romig was that the FCDA, a special law that took effect in 1972 governing the foreign currency deposit system in the Philippines, prevails over the general law, and that is the NIRC of 1997 on national internal revenue taxes. The second division used the rule on statutory construction, that a later law, general in terms and not expressly repealing or amending a prior special law, will not ordinarily affect the provisions of the earlier statute. So in this case, the FCDA. Consequently, then, the CTA Second Division ruled that the estate of Romig can claim the refund on the estate tax paid, since the FCDA is the governing law on the exemption from estate tax of foreign currency deposits.
Did the CTA on bank totally affirm your ruling at the CTA Second Division?
Interestingly, while the CTA Bank agrees with the other declarations of the second division, like the finding that administrative and judicial claims were timely filed, the CTA Bank nevertheless held that the HSBC US dollar savings account of Romig was not exempt from
Mm.
estate tax. For the court and bank, the decedent's foreign currency deposit then was correctly and legally included in the net estate subject to estate tax. As
Mhm.
a result, the CTAN Bank found that there was no erroneous payment of estate tax that could be subject of a refund.
Mhm.
However, based on our own internal rules, as the required number of votes to reverse a CTA division decision was not obtained. In this case, pursuant to our rules, the decision of the second division to refund
Mhm.
the estate tax paid based on the exemption provided under the FCDA was affirmed. So
Mm.
technically, because of the lack of votes, the decision of the CTA second division was maintained,
Right. So
and that is to refund.
to refund, right?
Yes.
So to settle all this, the case went to the Supreme Court, and the issue there is whether foreign currency savings accounts are exempted from estate taxes in the Philippines. What did the Supreme Court say after reviewing the relevant provisions of the tax code in relation to the Foreign Currency Deposit Act?
The Supreme Court ruled that, similar to the findings of the CTA Second Division, the decedent's US dollar savings in HSBC is exempt from estate tax pursuant to the FCDA. According to the Supreme Court, there is nothing in the NIRC of 1997 as amended that explicitly revokes the tax exemption found under Section 6 of the FCDA. So the SC explained, similar to what the CTA division has ruled, that a special law cannot be repealed or modified by a subsequently enacted general law in the absence of any express provision in the latter law to that effect.
So in short, you were sustained by the
Yes,
Supreme Court,
yes.
right? So what does this mean? What's the implication of this ruling? Does this mean that all foreign currency deposit accounts are exempt from estate taxes?
Yes, we can say that. Section 6 of the FCDA unequivocally states that the foreign currency deposit accounts are exempted from any or all taxes, including estate tax, irrespective of whether the residents or non-residents made these deposits, so long as the deposits are allowed under our laws. Like, let's say, the FCDA, we have also PD 1034 on offshore banking, and PD 1035 on the expanded authority of depository banks.
And Justice Jenny also raised as an issue before the Supreme Court in this case is the period for filing administrative and judicial claims for refund. I understand there's a 2-year requirement, 2-year period requirement under the tax code. Did the estate file both claims within this prescribed period?
Okay, so sections 204 and 229 of our tax code as amended provide for the refund of erroneously or illegally collected taxes, such as the case of Romig. Section 204 applies to administrative claims for refund, while Section 299 or 229 to judicial claims for refund. So both sections require the concurrence of two conditions. First, you have the administrative claim for refund. It must precede the filing of a judicial claim. Then second, both claims must be filed within 2 years from the payment of the tax. Affirming the findings of the CTA in division, the Supreme Court, in the case of Romig, found that both conditions were satisfied in this case. The administrative claim was filed at 8 o'clock in the morning, preceding the judicial claim, which was filed on the same day, but around 4:47 p.m. And second, both claims were filed on 28 June 2017 within 2 years from the payment of estate tax on 30 June 2015.
Mhm. And did the Supreme Court say anything about the brief interval between the estate's filing of the administrative and judicial refund claims? Because they were filed on the same day, just hours
Yes.
apart.
Yes, citing the landmark case of CIR versus carrier heir, the Supreme Court found that the brief interval between the administrative claim and the judicial claim is of no moment since it's a plain language of the law. As earlier stated, the law only requires two conditions. The administrative claim must be filed prior to the judicial claim, and both claims must be filed within 2 years from the payment of the tax.
Mm. And finally, Justice Jenny, what should our listeners take away from this case? What should they keep in mind with regards to foreign currency deposit accounts?
All right. So the Supreme Court's ruling in this case reaffirms the long-standing rule that foreign currency deposits authorized under the FCDA are considered of an absolutely confidential nature and in no instance shall be examined, inquired, or looked into by any person, even government officials or offices, whether judicial, administrative, or legislative, even after the death of the depositor, save only for a few exceptions, like there is a written permission or through a court order in connection with a violation of the AMLA law or the Anti Money Laundering Act. This can be used as a potential estate planning tool for preserving wealth and tax minimization. In estate planning, this absolute confidentiality may be viewed as double-edged sword, Attorney Mike. On one
Mhm.
hand, it offers a legitimate asset protection mechanism, shielding foreign currency deposits from undue scrutiny while simultaneously advancing the state's policy of beefing up the country's international reserve. On the other hand, however, it carries the risk of being exploited as a conduit for the concealment of assets.
I'm sure many will be interested whether to exploit or to take advantage of estate planning. So, thank you so much again for
Thank you
joining
also,
us
Attorney
today,
Mike.
Justice Jenny. And if you wish to read the full text of the decision of the Supreme Court, look for GR number 262092, Commissioner of Internal Revenue versus Estate of Mr. Charles Marvin Romig, represented by its sole heir, Maricel Narciso Romig. And here's Stiff Atendido Beltran, Supreme Court Information Officer, for this week's roundup.
From the Supreme Court of the Philippines, here's the latest. The Supreme Court has ruled that in drug cases, prosecutors must raise all their objections when an accused offers to plead guilty to a lesser crime. Any objections not raised are considered waived. The SC On Bank, through Associate Justice Japar de Maampao, reinstated the Regional Trial Court's ruling that upheld a man's plea bargain to the lesser crime of illegal possession of drug paraphernalia, despite objections from the prosecution. The SC reiterated the Montiero ruling that courts may reject the prosecution's objection to a plea bargain in drug cases if the only reason for the objection is that the plea violates DOJ rules, as long as the plea follows the SC's official plea bargaining framework. The SC updated its clarificatory guidelines on plea bargaining in drugs cases, initially set in the 2022 case of People v. Montiero. Aside from waiver of objections not raised by the prosecution, The additional guidelines in Aquino versus People allow appellate courts and the Supreme Court to order a lower court to either rule on objections raised by the prosecution or to render a ruling in accordance with SC guidelines. Honorable Mario Lopez, the 185th Associate Justice of the Supreme Court of the Philippines, has retired on June 4, 2025. After serving the government for over 40 years, 33 years of which were spent in the judiciary. On Tuesday, June 3, 2025, the court held a special en banc session in honor of Justice Lopez's retirement at the en banc session hall. Per tradition, each member of the court gave tributes and presented tokens to Justice Lopez. A mass and a short testimonial in honor of Justice Lopez were also held on Monday. Justice Lopez was appointed to the High Court on December 5, 2019. On June 3, Chief Justice Alexander Hismundo highlighted key reforms in strengthening the judicial framework for child protection in his keynote address at the Celebrating the Wins of Safer Kids PH program held in Makati City. Chief Justice Hismundo described Safer Kids PH as a beacon of hope in the fight against online sexual abuse and exploitation of children in the Philippines. An initiative of the Australian Government Department of Foreign Affairs and Trade, the program was implemented from 2019 to 2025 through a consortium of Save the Children Philippines, the Asia Foundation, and UNICEF Philippines. On Wednesday, Chief Justice Hismundo underscored the importance of interagency open communication, collaboration, and cooperation, and reaffirmed the judiciary's commitment in transforming the justice system at the Second National Justice Zone Summit held in Pasig City. The Chief Justice proudly shared that 10 out of the 16 justice zones were launched during his tenure, including the specialty zones. The Chief Justice credited SC Associate Justice Maria Filomena Singh for the idea of creating justice zones in 2014. Justice Singh on the same day was presented an award of appreciation for bringing vision, credibility, and unity to the table as a passionate advocate of the coordination mechanism under the Justice Zones program. Court of Appeals Associate Justice Wilhelmina Jorge Wagan accepted the recognition on her behalf, while CA Associate Justice Jaime Caringal delivered Justice Singh's lecture. Organized by the European Union's Governance and Justice 2 program, or GoJust 2, the summit brought together Justice Zone's stakeholders across the country to discuss milestones and recognize key contributions. Meanwhile, Chief Justice Hismundo feted the Sandigan Bayan's commitment to justice, public service, and excellence as the court with the highest case disposition rate in the entire judiciary at their 47th anniversary celebration on June 4 in Quezon City. The Anti-Graft Court was established on June 11, 1978 by virtue of Presidential Decree 1486 pursuant to the 1973 Constitution. Finally, on Thursday, the Sandigan Bayan held a retirement ceremony in honor of Associate Justice Bernalito R. Fernandez, who will compulsorily retire on June 9, 2025. A senior member of the 3rd Division, Justice Fernandez was appointed to the Anti-Graft Court on October 28, 2016. You are now up to date with the Philippine Supreme Court. I am Tiffany Beltran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Karen Martinez, J.R. Empilio, and May Sibal as researchers, Brian Austria, Don Ryan Balza, Victor Laranio, Lawrence Zolanio, Austin Aliscad, and Bea Batong as audio and video editors, and Tyke Flores and Jerome Batumalake as web editors.